We'll take questions. Any questions here? Yes, ma'am.
I know you all have been arguing, mainly Congressman Biggs, that it's a misinterpretation of the 14th Amendment. Of course, some are arguing, though, that this is a change to the U.S. Constitution. So can you just detail what's changed over the years in order to warrant this action?
Are you talking about over how it's morphed into what it's become today, right?
Right.
Well, I'll tell you, and I'm not a lawyer. Andy is, but I will say this. A person in the United States illegally are not subject to the jurisdiction thereof, because that's what the 14th Amendment says. They got no Social Security number. They got no voter registration, no jury duty. A lot of them are living in sanctuary cities. And by that very definition, they are exempt from the jurisdiction thereof of the United States government. And so the whole thing is a sham. It has been misused. It has been misinterpreted. And quite frankly, it is a joke how this thing has evolved over the last 150 years. Now, if you could give us, maybe, Andy, if you want to give maybe a more legalese. I'm a dentist, okay? I get to the root of problems. He can talk about that, I guess, as an attorney.
I'll just talk briefly rather than give a whole summation. But I will tell you this: I do believe the U.S. Supreme Court, when this gets there, because this will be litigated, I believe, and when it gets there, the U.S. Supreme Court is going to take a rationale somewhat similar to what I iterated earlier today, and that is, for instance, in the 1924 Indian Citizenship Act. Why did you have to do that? It's because the lawmakers of the time believed that you didn't have sovereignty. That was a independent sovereign nation that the Indian nations were. So there was no loyalty, which meant there was no jurisdiction thereof. So the term subject to the jurisdiction thereof actually had a meaning more than just saying that you're subject to be prosecuted or get voting rights, etc. It meant that you had developed a loyalty to the country, and so. That was very, very different, and so when we talk about misinterpretation, the case that I was citing in the late 1800s of the Wong Kim Ark case, don't forget what they really said is you got to be permanent, you got to be legal, in order to get birthright citizenship. The Roosevelt administration under FDR, they're the ones that actually kind of bastardized that and kind of expanded that. And so that's why I believe ultimately, and I'm predicting and forecasting, that when this gets to the U.S. Supreme Court, the U.S. Supreme Court's going to rule that this particular piece of legislation is constitutional.
Just a quick follow-up. Will you guys work to try to get this as part of the reconciliation bill, the board policies in that bill?
I would love for it to be there. But there's some technical rules with regard to oh, go ahead. I'll let John
go ahead, John.
Yeah, John.
Well, I think Representative Biggs has made the point. This is not a change of the Constitution. We're not talking about changing constitutional law, and I think he's made that point. So this is common sense on the first hand, but if you think about it from the legal interpretation of the language of the 14th Amendment, and again, I think he's made this point, it's not just about being born in the United States. It's about being subject to the jurisdiction. Lawyers study jurisdiction. It's a multifaceted question. Jurisdiction includes subject matter jurisdiction. It includes physical jurisdiction, to be sure, but it doesn't just include physical jurisdiction. In other words, you don't just have to have control of the person, and some people might look at this simplistically. And then there is legal jurisdiction. And so when the framers of the 14th Amendment were doing this, I think by putting that language in there, they understood that jurisdiction in the subject to the jurisdiction in the broadest sense. And so we're not asking for the Constitution to be changed. We're just asking for it to be applied and interpreted as it was intended and as it was written.
And as far as reconciliation goes, and I think several of these ladies and gentlemen up here have already addressed the fact that how much tax money could be saved if we did away with this. So I think it could be easily placed in reconciliation. Although I'm not. Anybody else want to have anything to say about that? About reconciliation?
Go ahead.
Yeah.
No.
I think in time, I doubt it will be in this package this year. We've got enough issues to debate and enough cuts that we're going to have to make. Because I think, this has got a dollar value. Assigning a dollar value would be tough. The other thing, we don't know how many people are in here now. I mean, when you come in illegally, I've heard 15 million. I've heard President Trump say 21 million. So we don't have an idea of the number. So assigning a dollar figure to the cost, which you have to do in reconciliation, would be tough to do. So we're going to have enough struggles just to have the cuts to make this country solvent.
Mr. Weber?
Yeah, I was looking through, I downloaded the 14th Amendment. There's been a lot of Supreme Court cases. Civil Rights Act of 1964 was upheld. This approach in the heart of Atlanta Motel versus United States. Justice Joseph Bradley made a really interesting comment about it. He said, quote, individual invasion of individual rights is not the subject matter of the 14th Amendment. It has a deeper and broader scope. It nullifies and makes void all state legislation and state action of every kind which impairs the privileges and immunities of citizens of the United States or which injures them in life, liberty, or property without due process of law or which denies them equal protection of the laws. He goes on. The radical Republicans who advanced the 13th Amendment, which was free slavery, abolishing slavery, hoped to ensure broad civil and human rights for the newly freed people. But its scope was disputed before it even went into effect. The framers of the 14th Amendment wanted these principles enshrined in the Constitution to protect the new Civil Rights Act from being declared unconstitutional by the Supreme Court and also to prevent a future Congress from altering it by a mere majority vote. Who was the focus? The newly freed people. Not everybody trying to get here by hook, crook, or cranny.